All right, y'all, what's up? Check me out. Welcome to the Podcast with Soul. Follow me on all my platforms. Spotify, the Podcast with Soul. TikTok, my back itching. Podcast with Soul. Instagram, the Podcast with Soul. YouTube, the Podcast with Soul. I don't wish to defame, slander, or libel anybody as it relates to what I'm going to talk about today, which is going to be the Southern District of New York's response to Puffy's request for Rule 29 and a Rule 33. This is a 58-page document dated August the 20th, 2025. In this document, at the beginning, starting on page 3, they list 84 individual cases of precedents where they're going to reference throughout what they talk about in this document. See all those cases? More cases. This is in response to Alexandra Shapiro's request for Rule 29. Also, Tenny Garagos and Mark Agnifalo's request, Puffy's legal team's request for a Rule 29, which is a judgment of acquittal. They're asking for Judge Submaranian to just acquit Puffy of the two Mann Act charges. If the Judge Submaranian chooses not to acquit Puffy, Puffy's lawyers have asked for Judge Submaranian to grant a new trial under Rule 33 for misjoinder spillover, meaning that a lot of the evidence and testimony that was given throughout the RICO trial, for which Puffy was 1 count of racketeering conspiracy, 2 counts of sex trafficking, 2 counts of the Mann Act, that a lot of the witnesses and testimony and evidence that was entered during the trial when Puffy was fighting the racketeering conspiracy and fighting the 2 sex trafficking wouldn't have been submitted and allowed as evidence in just the Mann Act charge. And that now that he's been acquitted of the RICO racketeering conspiracy, acquitted of the 2 sex trafficking charges, the Mann Act charges have to stand on their own 2 feet. One very important part of the Mann Act as it relates to Cassie is that there is a 5-year statute of limitation on the Mann Act. And if we're talking about Cassie and Cassie alone, that statute of limitations would have expired. It would have run its part. Because the last time Puffy got it, did anything with Cassie on that tip, as far as a freak off, was in 2017, 2018. Now, I have some notes that I wrote down that I'm going to be using. First of all, I want to say right off the top that I read this document, and I think just in this video, I'm going to deal with the Rule 29, and then maybe in another video, I'll do the Rule 33. In Alexander Shapiro requested a Rule 29. This probably was like maybe week 5 or week 6 of the trial. After she had requested, I think, 2 mistrials for prosecutorial misconduct and the removal of juror number 6. And Judge Submaranian has yet to rule on the Look at that steam coming off my coffee. My coffee is the best. Judge Submarani has yet to rule on the Rule 29 or the Rule 33. In Alexandra Shapiro's and in Mark Agnifilo and Tenny Garagos's letter concerning the Rule 29 and the Rule 33, what was uncovered is that prostitution charges are typically handled by states. Federal prosecution of prostitution is rare. And in Alexander Shapiro's letter, I don't have it with me. I don't have my notes, but I'm going to come off the top of the dome, so I may be a little off. But if you look at some past videos where I was actually reading from the document, or you can get the document itself online at pacer.com, as you can get this document. It's public information. The feds had a dictum or a dictate or a maxim that the federal prostitution, the Mann Act, would only be prosecuted only if it was in the form of someone making a financial gain, meaning brothels, madams, and pimps, okay? People that were in the business of prostitution to make money. That was in one of the, that's coming from the Department of Justice, okay? Also, along with that, there has to be some underlying other offenses like SEX trafficking or kidnapping or immigrants brought to America and their identification and passport information taken from them, and they are like forced into a life of selling themselves for the benefit, for the financial gain of a pimp, a brothel, or a racketeering conspiracy, as we saw in the Hernandez, Hernandez Enriquez case, the Hernandez case, the Tills and Trowbridge case, Abercrombie and Fitch. These were some of the major elements that needed to be in place in order for the feds to pick up a Mann Act charge. Initially, at the outset, the underlying premise for the Mann Act, which initially at first was called the White Slave Traffic Act, which was geared toward preventing women and young girls from being recruited into prostitution, going back to the early part of the 20th century, the 1910s, the 1917s. It even went further back. If you look at it, it goes back into the mid-19th century, 1847, the late 1800s. And that was the underlying premise. And then this senator with the last name of Mann came along and amended it and did it. And that's what it was typically used for, transporting women and girls across state lines to engage in prostitution. It's been amended several times after that. Language has been changed. The Southern District of New York talks about that in this document. Now it's called any sexual activity. It doesn't necessarily have to be immoral in nature or debauchery. A lot of language has been changed. And, they brought that up. But at the end of the day, it, on the federal level, it typically is not prosecuted unless there is a financial gain from the party engaging in the prostitution. That is clearly not the case with Puff and Jane Doe and Cassie. Number one, Jane Doe was a willing participant in these freak-offs with Cabral, with Paul, with Don. She arranged a lot of the freak-offs. This was her occupation. She had an OnlyFans page. She, this is what she did. There was no force. There was no coercion as far as Jane Doe is concerned. So this is a willing participant. Jane Doe is a willing participant, an adult of adult age, of sound mind and body, willing to engage in the swingers lifestyle, the voyeurism, as they call it. There was no force. The drugs that she took at these freak-offs, and a freak-off, let's be clear, is not what Courtney Burgess and Ariel Mitchell said they were. A freak-off is not what the mainstream media and other rappers who are jealous of Puff, who are intimidated by Puff, said they were. A freak-off is not what the gossip and the rumor mill had it, that it was this big party where there was an orgy type situation where condoms are all over the floor and you go into this secret room and anything goes. That's not what a freak-off was. A freak-off was nothing more than one woman, one man, and a male escort. That was it. A hotel night was nothing more than one woman, one man, and a male escort. For the freak-off, that was Cassie, Puffy, and a male escort. For the hotel night, that was Jane Doe, Puffy, and a male escort. That was it. I was blown away when I got to the trial, which I attended every single day in the Southern District of New York, 500 Pearl Street. I missed maybe 4 or 5 days of being there in person, but I was there every day. But let me tell you, I was shocked when I found out that that's all a freak-off was, because that's not what they said it was in mainstream media. I was led to believe that it was what I initially described, and none of that was true. That was the furthest thing from the truth. Cassie also was a willing participant. There was no force with Cassie. There was no coercion. So let me just make a quick point and then I'm going to come back. There was no force for Cassie. There was no coercion. Cassie set up the freak-offs. Cassie reached out to the male escorts for the freak-off. Cassie saw and remained in contact and had sex with the male escorts when Puffy wasn't around. Now, Puffy, the Mann Act is 18 USC 2421. That is it. That is all Puffy was convicted of. That's all a Mann Act is. And as I told you earlier, typically the feds don't prosecute that unless you're in it to make a financial gain. You're in it to make a profit. That prostitution is your business. This is not the case with Puff. There is no Puffy is convicted for 2421, 18 USC 2421, 18 2422 is also Mann Act, but it involves force and coercion. That is not the case here, although the Southern District of New York tries to insert and relitigate that there was force and coercion with Puffy performing the Mann Act. That's bullshit. There was no force and coercion because the male escorts that are doing interviews now on YouTube that were in relationships with Cassie won for 7-8 years, right? The Punisher, Sherrod Hayes, came and testified at the trial. I was there. He said there was never no force or coercion, that Cassie wanted it. She was a willing participant. The same thing with Daniel Phillip, who came to testify at the trial. She was a willing participant. She wanted it. They remained in touch. Even years after they fell out of touch, Cassie saw Daniel Phillip with another woman, and she wanted to have sex with him then, long after she was done with Puff. So there is no force, there is no coercion. Cassie and Jane Doe are adults. The drugs that they took, the drugs that Daniel Phillip took, the drugs that Clayton Howard took, and Clayton Howard expressly stated on some of the interviews that some days I didn't want it. Then some days I indulged. These are adults. They were not forced to take drugs. They were not tied down and ingested with drugs. The drugs was there. Puffy was involved with drugs, and maybe he asked, hey, do you guys want to get down? You want some? You want some? And they all took it. Cassie, Jane, and the male escorts. But these are all adults, consenting adults, engaging in the personal use of drugs, and consenting adults engaging in a swingers lifestyle. Now, Puffy did not make any money from the threesomes that he put together with him, Cassie or Jane, and a male escort. A lot of times he hired the male escorts from Cowboys for Angels and Hunkomania, and he paid the company for the time of the male escort. That is what came out at the trial. The male escort would come to wherever they were and would get a tip. Yes, Puffy did pay for flights. He did pay for hotel rooms for the male escorts. He did transport the male escorts from different cities. LA, New York, Miami, Las Vegas. 1000% true. They showed that in the trial with the credit card receipts and the itineraries. That's true. But this was what Jane wanted or what Cassie wanted. They were willing participants. They all got off on that typical lifestyle, and that's what it was. So in this document, and I'm reading this document, this was submitted by the Southern District of New York. Number one, right off the top, the Southern District of New York, you guys lost. And this is signed by, Jay Clayton's name is on this, but I don't believe Jay Clayton wrote this. Any document that comes out of the Southern District of New York is going to have Jay Clayton's name on it. Here it is. Any document that comes out of the Southern District of New York is going to have Jay Clayton's name on it. Okay. You see that? United States Attorney Jay Clayton. And then underneath there, you have Meredith Foster, Emily Johnson, Christy Slavic, Madison Reddick Smizer, and Mitzi Steiner, Assistant United States Attorneys. You guys lost. The Southern District of New York, you got beat. You lost. You did not win. Judge Submaranian saw you lose. I saw you lose. You saw you lose. The whole world saw you lose. And the lead prosecutor, your leader, Maureen Comey, got fired as a result of this case. There was tremendous prosecutorial misconduct that went on in this case that you guys engaged in. Invading Puffy's, shaking down his cell at MDC Brooklyn and taking pictures of his attorney notes, violating his attorney-client privilege, violating his filter zone, putting witnesses on the stand that committed perjury, several of them. You guys got beat. You lost. You lost. You lost. And Judge Submaranian, I know you are an alumni of the Southern District of New York. I read your bio. You born in Pittsburgh and did a lot of clerkship. I think Ruth Bader Ginsburg. You did a lot of clerkships in the Southern District of New York. So this is your crew, and your check is signed by the Southern District of New York. But you're a judge now, right? And you have to stick to the law. You have to stick to the law. You have to divorce yourself from your emotional connection and your mental connection to the Southern District of New York. And you sat there and you saw them get beat, soundly beat. And that's it. Now, the way that I've seen it, the way I see it, I make the best coffee ever. My coffee is the best. The way I see it, Judge Submaranian, you're from Pittsburgh, Pennsylvania. You were born there. You're of Indian descent. But you're born in Pittsburgh. You're probably a Pittsburgh Steelers fan, maybe a Pittsburgh Pirates fan, maybe a Pittsburgh Penguins fan, most likely a Steelers fan. I don't know this to be fact, but you're born in Pittsburgh. In the Super Bowl, Judge Submaranian, and you're of Indian descent, so maybe you like cricket, right? When the best cricket team from one part of India and the best cricket team from another part of India, after they've beaten everybody and the two best teams come together to play for the championship, after the Pittsburgh Steelers go to the Super Bowl or to the conference finals or the playoffs, the losing team doesn't get a say. The reporters don't want to go into the losers' locker room. Sponsors don't want to do nothing with the losing team, right? The losing team can't make an argument as to you lost. You got your ass kicked. That's it. When the two best cricket teams play and the cricket team that loses, nobody wants to go see them. Nobody wants to talk. Only their family, right? Everybody wants the winners. To the winner go the spoils. The winners are the ones that get the breaks. The winners are the ones that get the endorsement deals. The winners are the ones that get the fly honeys. The winners are the ones that get the trophy and the medals and the cash prize, not the losers. These girls, and there's nothing personal against them, including Jay Clayton. But Jay Clayton inherited this mess from Damian Williams. They lost. But now they want to come and submit to you a 58-page document still talking about violence, still talking about force, still talking about distribution, possession with the intent to distribute, still talking about trafficking, still talking about forced labor. And Puffy was acquitted for all of those things. But here they are. But this is what they do. The Southern District of New York has been exposed as cheaters, and they cheated at his trial every day. You know, why is it that Judge Submarinian, this is a question for you. Everybody send this video to Judge Submarinian. Why is Cassie free? Why is Jane Doe free? I understand it because they were cooperating witnesses. They were cooperating individuals. They cooperated against Puffy, testified against Puffy, got on the stand, pointed to him. Cassie sued him for $20 million. Jane didn't sue him yet, but that would have came had he lost. But so they wouldn't be implicated in a federal case, a Mann Act case. They agreed to testify against Puff. Both of them are free. All of the male escorts are free. No charges. Only 2 of them came to testify at the trial, and there were many. Hunkamania is an ongoing concern, still up and running, not shut down. Cowboys for Angels, a going concern, up and running for business, not shut down. And what's funny is that Clayton Howard has stated that he too was brought before the grand jury and was going to be called as a witness in this case against Puff. But Maureen Comey in the Southern District of New York decided not to use him because they wanted him to lie on Puff and say things that weren't true in order to help to win a conviction. And he wouldn't do it. So his name is mentioned in here. Daniel Phillips' name is mentioned in here. So, I mean, what are we doing here, man? There is so much wrong. And in Alexandra Shapiro's letter, there's something that she kept quoting, which was called exceptional reasons. Exceptional reasons. Exceptional reasons. Send this video to Jason Driscoll and send this video to Alexandra Shapiro. That Puffy's conviction of the Mann Act has exceptional reasons. And it's all over it, right? Number 1, these were consenting adults. Number 2, there was no sex trafficking. There was no force, okay? And he wasn't in it for a financial gain, right? Exceptional reason number 2. Exceptional reason number 3 is that the money, males were hired. It wasn't like females or girls were hired or minors. That wasn't the case, right? Which the minors would trigger the 24.22. These were men, grown men, consenting adults that carried on relationships with Jane Doe and with Cassie when Puff wasn't around. Cassie and Jane Doe got with these dudes when Puff was with his other honeys, and Jane Doe and Cassie let these dudes hit it on the strength, or maybe even for money. She might have been paying them. And in a lot of these cases, Cassie was the one paying. So was Jane Doe. There were instances, they say, where Puff did pay. But most of the times, it was Jane Doe and it was Cassie. These are the exceptional reasons. Another one of the exceptional reasons is that Puffy, Puffy's lawyers assert that this is his First Amendment right, that if he wants to film himself having a sexual experience with his lady friend and another man, that's clearly his right. Okay? There was no sex trafficking. Puffy was acquitted of that. There was no force. Puffy was acquitted of that. Okay? So Judge Submaranian, man, you gotta acquit Puffy of these charges, or you gotta give Puffy a new trial under Rule 33 that these Mann Act charges has to be tried alone, as standalone, based on the ruling that the Department of Justice said that these cases typically only get prosecuted on a federal level if it involves something for financial gain and there's some type of sex trafficking going on, and you know there's force and someone is taking advantage of somebody's immigration status and taking all their paperwork when they get here so they can't go to the cops. None of that existed in Puffy's case. This Puffy's entire conviction is an exceptional reason. It's an exceptional reason. You gotta see that. And Puffy won, Judge Submaranian. Puffy won. He beat the prosecution. The prosecution lost. So if there's any play or any leeway or any you gonna let something slide, it's gotta be to the winner, not the loser. What else I got here? I think that's it for my notes. So, you know, and in this, let's get into the paperwork. In this, the Southern District of New York, these girls here, Meredith Foster, Emily Johnson, Christy Slavic, Madison Reddick Smizer, and Mitzi Steiner, they're calling on precedents that happened in 1917, 1910, 100 years ago, where the attitudes and opinions of the public and the customs and ideologies of the public were entirely more restrictive, right? Way more conservative than where we are today. And these are some of the cases that they cite to justify you not acquitting Puffy under Rule 29 and you not acquitting Puffy under Rule 33. And let me say this here to you, Judge Submaranian, man, because I watched you and you didn't heard me say this before. You know, I think somebody's making you rule the way that you're ruling. Because I know for a fact, my back itching, hold up. That's all them pull-ups I'll be doing. Hold on, y'all. I know for a fact that you ran a fair trial. I've said that from the beginning. Everybody tries to call you a racist and say you're biased against Puff, but they don't know what the hell they're talking about. They saying that in the comment section behind a fake profile name, so you can't take none of them what they say. And none of them never went one day to the trial. And Puffy even got up in the courtroom, Judge Submaranian, and told you, thank you. These were his words. Thank you. And I think you're doing a great job. Those were his exact words to you. Your exact words to Puffy after he was acquitted and after Mark Agnifilo put forward a verbal motion that Puffy should be released on July the 2nd, 2025, when, per Mark's exact words, the jury gave him his life back. And that he can go home on conditions, whatever conditions you decided to set. And then Judge Submaranian, your exact words to Puffy on July the 2nd, 2025, before Maureen Comey got up. You asked Puffy, you looked him dead in his face, man. I saw you. I was there, man. I saw the whole thing. You was there. Puffy was there. We all was there. You looked at Puffy and you said, Mr. Combs, I'm sure you don't want to go back to MDC Brooklyn because you know yourself, Judge Submaranian, that MDC Brooklyn is fucked up. That It's under investigation. There's rats in there. There's bugs in the food. There's roaches. Um, it's understaffing. It's horrible. And Puffy looked at you when you asked him that, and Puffy shook his head. He said, "No, I don't." And you were gonna let him go, 1,000%. And then Maureen Comey stood up, who's since been fired, Judge Serene. She's fired. She's gone. The lead prosecutor, not only did she lose the case, then she got fired after it. Stood up and objected to what Mark Agnifilo said, and then you came back and you said some old bullshit about violence that Puffy did and whatever, and you denied him, man. But, at some point, man, Judge, you're going to have to be a judge, man. You went to Columbia University. You got your JD from Columbia University. You got to be a judge, man. You're the first South Asian judge in the Southern District of New York, district judge. And you know what, Judge Submaranian? The foundational Black American helped you. My people helped you. Puffy is foundational Black American. Puffy's people helped you. It was the fighting that we did, that my mother did in the 40s, 50s, and 60s, and the 70s, and the 80s, that opened up the door for a South Asian judge like you to become a judge in the Southern District of New York and to achieve what you've achieved. So you owe us. You're not from this country. I don't care if you was born in Pittsburgh. Your family are migrants. You guys are immigrants. You are not from this land. I am. This is my land. Same thing with Puff. We was here before the Pilgrims came, before the European got here. We was already here. And you owe respect for that, for what we did for you to put you in that position. Now, you done denied Puffy bail twice. To come sentencing, you got to do the right thing, man. You got to go by the law. You know the law. You done did clerkships with district judges. You done worked at Godfrey, that law firm, that White Shoes law firm, the elite level law firm. Go by the law, man. Stick to the truth, man. Stick to the truth and administer justice. Outside in Foley Square, on the top of that building, I think it's the New York Supreme Court, it says, "The true administration of justice is the firmest pillar for good government." I don't know who's bullying you or who's making you do whatever, but man, you got to be a man, man. Judge Summerlin, you got to be a man. You younger than me. I got you by like about 10 years. I'm 56. I think you like 45, 46. You got to stand up, man, and accept yourself first before you try to receive acceptance from some superiors or from some other people that just don't like Puff for whatever reason. You know what I'm saying? You a judge, you got to be a judge. And you got to judge this thing right and fair. Puffy should have been home. Been home. A girl came in your courtroom and perjured herself, Breonna Boglin, in front of your face, disrespected you, disrespected your court. Nothing still ain't been done to that girl. So you got to step up to the plate, man. Preliminary statement. The government respectfully submits this memorandum of law in opposition to the defendant's renewed motion for judgment of acquittal or, in the alternative, a new trial. The defendant, following a conviction at trial on 2 felony Mann Act counts, advocates for the court to narrow the scope of the Mann Act to exclude his own criminal conduct on the grounds that, among other things, the statute is unduly vague, which it is, violates his substantive due process rights, and violates his First Amendment rights. The defendant further contends that the record at trial fails to support his conviction. The defendant is mistaken as a matter of fact and law. Bottom of page 1. The defendant masterminded every aspect of freak-offs. That's a lie. That's a lie, Judge Submaranian. They lying again. You know, you was in court and I was in court too. Cassie and Jane Doe were just as an integral part of mentally putting the freak-offs together. Jane Doe would go and buy special outfits for the hotel nights. She would buy special outfits for Puffy and the male escort to wear. Okay? She would go out or send the assistant out to buy her a certain kind of heels and lingerie. We heard that at the trial, Judge Submaranian. Cassie, remember this part? On Valentine's Day, she went and had a hotel room. It was a surprise for Puff. And she, with rose petals, she put a heart on the bed. You know, all in arranging for a freak off for Puff as a surprise gift. Jane Doe also put together an all-star party where she herself masterminded the whole thing and invited 4 male escorts that she was gonna let knock her down for Puff. The all-star party. So this is a lie. The defendant dated Cassie Ventura from approximately 2008 through 2018, and Jane Doe from approximately 2021 to 2024. So if Puffy dated Judge Submaranian and Jane Doe from 2018, is her 5-year statute of limitations still in effect? Hasn't that expired? During these relationships, he exerted substantial control over Ventura and Jane's lives. That's a lie. Jane Doe lived a half an hour away from him, and he still only saw her every 5 weeks to 2 months. That came out at the trial. That's exerting control over somebody. Jane Doe wanted to be his girlfriend, Judge Submaranian. You heard it. And he told her, no, I'm single. I got you and I got a bunch of other honeys. Cassie had relationships with Kid Cudi, Brianna Boglin, an NFL player, and Michael B. Jordan. So she was having all of these, and she was seeing some of the male escorts when Puffy wasn't around. So how could he control every aspect of her life? All lies, man. This is page 2, page 10 of 58. Page 11 of 58. As a part of these nights, the defendant required Cassie and Jane to have sex with male commercial sex workers while he directed, watched, and masturbated. The freak-offs and hotel nights typically lasted several days, during which the women did not sleep and would be kept awake using drugs provided by the defendant. Why are they wording this like this, Justin? Like he made them stay awake. They wanted it. Jane Doe testified on the stand, Judge Submaranian. You heard it, that she loved Paul. She had a special affection for Don. That they were more, it was more of a friendship. Okay? The same thing with Cassie and Clayton Howard. Right? And the male escorts that she was involved in. The sex acts at freak-offs and hotel nights followed the same typical patterns, which was directed by the defendant. No, which was dictated by the defendant. That's not true. So what they're implying here, that it was dictated, that they were forced. Not forced. They were willing participants. Continued application of baby oil, mutual touching and masturbation, oral sex, and penetrative sex. Freak-offs and hotel nights took place often, sometimes on a weekly or monthly basis. They were willing participants. Look at this part, bottom of page 3, page 11 of 58. The defendant forced them to participate in hotel nights. This is a lie. This is a lie. Puffy was acquitted of trafficking and force and coercion. These were willing participants. Look at how they continue to lie. The defendant forced them to participate in hotel nights when they were still recovering from urinary tract infections, when they were on their periods, when they were vomiting, when they had physical injuries, and after they blacked out on drugs. That's a lie. Because Daniel Phillip said in one of his interviews on YouTube that, or Clayton Howard said it, that after Cassie woke up from a blackout, she was the one that demanded that her and Clayton Howard continue to do a freak off. Judge Submarinian, these girls right here, these assistant U.S. attorneys from your alumni, they lost. They lied at the trial, and they're continuing to lie in this document. This, they bring a bad reputation to the Southern District of New York, man. Maureen Comey, Meredith Foster, Emily Johnson, Christy Slavic, Madison Reddick Smizer, Missy Stein, and Damian Johnson, they brought shame and ill repute and brand damage to the Southern District of New York. Here they are continuing to lie. After they lied at trial. Page 15 of 58, page 7 of the document. Both Cassie and Jane did not want to have sex with escorts and told Puffy they did not want to have freak-offs or hotel nights. Judge Submarinian, another lie. Another lie. We saw the text messages where Puffy told Cassie, early on in their relationship, let's do one more freak off and that's it. I don't want to do no more freak offs. And Cassie texted him back saying, what? The last freak off we had is the first of the rest of our lives. I always want to freak off with you. She said that. Page 16 of 58. The court should deny the defendant's motion for a judgment of acquittal. Federal Rule of Criminal Procedure 29 provides a mechanism for the court to enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. Under Rule 29, a defendant challenging the sufficiency of evidence to support his conviction bears a heavy burden. The question is not whether this court believes that the evidence at trial established guilt beyond a reasonable doubt, but rather whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. In considering a Rule 29 motion, the court must view the evidence in the light most favorable to the government, analyze the pieces of evidence in conjunction and not in isolation as to the totality of the government's case, and not to each element as each fact may gain color from others. And this is the part where with the misjoined spillover that's in Rule 33 is even mentioned here, right? That some of the evidence from the RICO and the SEX trafficking spills over. Among other reasons, page 18 of 58. page 18 of 58. Among other reasons, the defendant's motion should be denied because the defendant's arguments, with the exception of those regarding sufficiency of the evidence in section 1C of the defendant's motion, are not, in fact, proper Rule 29 arguments. Rule 29 only authorizes motions challenging the sufficiency of the evidence presented at trial. Rule 29C is not an open-ended opportunity to relitigate unfavorable rulings, contest jury instructions, or advance new legal theories. All right, cool. Rule 29 only authorizes motions challenging the sufficiency of the evidence presented at trial. What about the perjury? The evidence that the Southern District of New York presented at the trial. That was sufficient with Breonna Bogelin, Dawn Richard, Mia, Capricorn Clark, Kid Cudi, all of the Jane Doe, Cassie, all of them committed perjury. Is not an open-ended opportunity to relitigate unfavorable rulings. So then why are they, check this part out, Judge Submarinian. Rule 29C is not an open-ended opportunity to relitigate unfavorable rulings, contest jury instructions, or advance new legal theories. So then why are they early on in this document talking about Puffy forced them to do freak-offs? He made them stay awake by giving them drugs. All of these were predicate offenses that he was acquitted of. So aren't they relitigating the case in this document? Page 19 of 58. Accordingly, courts routinely deny Rule 29 motions where the motion primarily raises legal or constitutional arguments that could have been raised pre-trial. Similarly, a Rule 29 motion must be denied where it effectively seeks to assert an after-the-fact challenge to the district court's jury instructions. Page 20 of 58. The defendant then asks the court to interpret the Mann Act to apply narrowly to only a specific class of defendants, which would exclude the defendant, specifically only those that have a commercial motive or who have sex with adult prostitute, and only those who do not film the interaction. But these are arguments that should have been brought under Rule 12 or at the jury charge conference. They are not Rule 29 insufficiency arguments. The indictment also nowhere alleged that the defendant had a commercial motive to engage in the offense or that he had sex with the adult prostitute. Thus, the basis for the defendant's newly asserted vagueness, substantive due process, and First Amendment arguments were all reasonably available to the defendant based on the face of the indictment that should have been raised pre-trial, if at all, under Rule 12. Page 21 of 58. For example, as discussed further below, while Puffy now argues that Puffy's conduct does not fit the proper definition of prostitution, the defendant never raised this proper definition prior to the jury charge being issued and, in fact, advocated for the exact definition of prostitution that the court provided to the jury, defining prostitution as the practice or an instance of engaging in sexual activity for money or its equivalent. But this is not the Mann Act as far as the federal the mandate that the Department of Justice put down, that manual. This is not that. Plus, Judge Submarine, we both know that the states, typically the prison time at worst is 6 months imprisonment at the state level for prostitution. A lot of times they don't even bring a case. Further, the defendant should not now, after the jury has already convicted him of the Mann Act charges, be allowed to package these claims as insufficiency arguments and to end run the procedural requirements of challenging the court's interpretation of the Mann Act and its instructions to the jury on that crime. This is page 22 of 58. It does not stand for the proposition that a defendant can backdoor a waived challenge to the court's jury instructions through a Rule 29 motion for insufficient evidence. To permit otherwise would allow a defendant to waste court and jury resources by waiting only until after the jury convicted him to make a full-throated objection to the court's instructions on the relevant violations. Check this part out, what they wrote. To permit otherwise would allow the defendant to waste court and jury resources. Damian Williams, Maureen Comey, and those assistant U.S. attorneys already wasted court and jury resources by bringing this case. So here's page 23 of 58. Here's page 23 of 58. Under the Mann Act, whoever knowingly transports an individual in interstate or foreign commerce with the intent that such individual engage in prostitution or in any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be fined under this title or imprisoned not more than 10 years or both. The text of the statute provides two alternative ways of violating the Mann Act. Transporting an individual with the intent that they engage in prostitution, which this was not prostitution, Judge Submarine, you know that. These were consenting adults living a swinger's lifestyle. Transporting an individual with the intent that they engage in any sexual activity for which any person can be charged with a criminal offense. What was the criminal offense that they could be charged with? Consenting adults having sex in the privacy of their bedrooms. What's the criminal offense? In this case, Puffy was charged with transporting individuals for the purpose of prostitution. It was not prostitution because, number one, he himself didn't engage in sexual acts with the male escorts who were being transported. He was more like, as they put it in Alexander Shapiro's thing, he was more like a John who was watching. Yes, they mentioned it in here, and it did come out in court that he engaged in sexual acts with Cassie and Jane Doe while the male escort was there, okay? But he wasn't paying Jane Doe or Cassie. Those were his lady friends. The court instructed the jury on the definition of prostitution as proposed by the defendant, explaining that prostitution is the practice or an instance of engaging in sexual activity for money or its equivalent. The jury thus convicted the defendant on counts 3 and 5 based on the definition for prostitution provided by Puffy. This is page 16. At Puffy's request, the court defined prostitution as the practice or an instance of engaging in sexual activity for money or its equivalent. Not only did the defendant waive any argument as to the appropriateness of this definition, which clearly encompasses the defendant's conduct, was proper and consistent with the text of the statute and the federal case law interpreting the Mann Act. Listen, what Puffy's legal team or Puffy agreed to, as far as this Mann Act is concerned, listen, we can recognize and acknowledge that we made a mistake in the past and do something. We want to correct it today. That's what the appeals court is for, right? We can see where we overlooked something or we made a bad interpretation of law. So we appeal it. You can't, the appeal court just say, oh, well, you agreed to it then and it was wrong and it's going to stay wrong because you agreed to it as wrong, when they know that the law is the antithesis of what they agreed to. That's not how it works. So what? They maybe fucked up with the interpretation back then. They were trying to beat the RICO case and this SEX trafficking because that was the life in prison without the possibility of parole and the forfeiture of assets. Look at this. Look at what they put, Judge Submarine. Page 25 of 58. The Supreme Court has long been clear of the meaning of the term prostitution. In Cleveland versus the United States in 1946, 80 years ago, they're referencing a case that's 80 years old. Black's Law Dictionary. Prostitution, the practice or an instance of engaging in sexual activity for money or its equivalent, commercialized sex. Puffy wasn't engaging in sex with the male escorts. Page 26 of 58. To do so, the defendant urges the court should employ the canon of constitutional avoidance to construe the Mann Act. Page 27 of 58. The Mann Act criminalizes transportation for the purpose of prostitution, and as described above, the textual analysis makes clear that prostitution includes engaging in sexual activity for money or its equivalent. Puffy he wasn't engaging in sexual activity with the male escort. He was engaging in sexual activity with his ladies. The defendants suggested limitations to the definition of prostitution to those who are motivated by financial gain or those who themselves engage in sexual activity with an escort. Find no support in the text or the case law. This is the critical piece, Judge Submarine, page 27 of 58, the last paragraph. There was no financial gain. Puffy had no financial gain. On page 28 of 58, look at the cases that the losers use as precedents. A case from 1946. Caminetti, a case from 1917, 109 years old. Another case from 1971. Another case from 1976. Caminetti was what? 19 what? Caminetti, 1917. And I think Alexander Shapiro or maybe even Tenney and them may have referenced that case. But this is 1917, man. This is over a century old. So if you're going to use the Caminetti case, page 29 of 58 in the subscript, the defendant suggests that Caminetti only related to the debauchery and immoral purposes language in the Mann Act. However, one of the Caminetti defendants was charged with inducing a woman to travel across state lines to engage in prostitution, debauchery, and other immoral practices. The evidence induced at trial indicated that the defendant paid the woman. Accordingly, the Supreme Court's analysis in Caminiti appeared to interpret the statute as a whole rather than just the debauchery and moral purpose language. There is no ambiguity in the terms of this act. It is specifically made an offense to knowingly transport or cause to be transported in interstate commerce any woman or girl for the purpose of prostitution or debauchery. Woman or girl. Woman or girl. These were male escorts. In addition, page 32 of 58. In addition, the Mann Act contains a common scienter requirement that the defendant must knowingly transport an individual or interstate or foreign commerce with intent that the individual engage in the act of prostitution. Page 33 of 58. Ignoring the ordinary meaning of the term prostitution and federal case law about that term, the defendant instead relies on state and local laws from Minnesota to Massachusetts to Texas to Washington to argue that the meaning of the term prostitution is amorphous and that the court should interpret prostitution not to apply to voyeuristic conduct like that at issue here. So Puffy's argument is that this is a swinger's lifestyle with voyeurism. He likes to get with his honey and hire a dude to come and knock his honey down. He liked to watch, right? He hires the dude from a legitimate for-profit business, a going concern, Hunkamania or Cowboys for Angels. The dude comes and Hunkamania and Cowboys for Angels expressly state on their websites that they do not engage in prostitution. So Puffy pays these websites or these companies. They send over the escort. They do their thing with the voyeurism. He gives them a tip. They knock his lady down while he's there. He watches, he masturbates, whatever he does. That's not prostitution because he doesn't engage in sex with the male escort. And he's not in it he doesn't make any money off of it. There's no financial gain. Page 33 of 58. Thus, the definition of prostitution under the Mann Act is not circumscribed by state law, but rather by the federal jurisprudence detailed above. The relevant state jurisdictions consistently define prostitution as sex for money or other consideration. A person is guilty of prostitution when such person engages or agrees or offers to engage in sexual conduct with another person in return for a fee. Prostitution means the giving or receiving of the body for sexual activity for hire, but excludes sexual activity between spouses. Further, page 3458. Further, while the defendant may wish to cabin his participation to mere voyeurism, he was in reality an active participant in the sexual activity. The defendant's argument is premised on the idea that he himself, Puffy, did not participate in sexual activity. However, as described above, the defendant, Puffy, fully participated in the sexual activity with escorts by directing the sexual conduct between escorts and victims. So what they're saying, what they're trying to say, Judge Submaranian, is that the fact that he was directing Cassie or Jane and what the male escorts to do, that was his participation, right? Another reference they have is Cassie was giving him oral sex while the male escort was knocking her down, right? So that's participating. That is participating, right? But still not making no money off of it, man. This case is weak, man. Page 35 of 38. The defense next takes aim at the Mann Act generally, arguing that the statute poses substantive due process concerns and should be construed narrowly as a result. Specifically, the defendant complains that recent expansions of sexual rights under federal law, including in the Supreme Court's case, is Lawrence Obergefell, which expanded the rights afforded to same-sex partners are hard to square with criminalizing a person's decision to pay for adult sex. Page 36 of 58. Puffy decided that he wanted a freak off. They all wanted freak offs. Page 37 to 38. Freak offs were solely for the defendant's sexual arousal and gratification. That's a lie. They lying, Judge Submaranian. Page 37 of 58, first paragraph. Freak offs was solely the defendant's. The freak offs was solely for the Puffy's sexual arousal and gratification. Neither Ventura nor Jane enjoyed having sex with strangers in front of the defendant. This is a fucking lie. Page 37 of 58. Jane Doe arranged the hotel nights. Cassie arranged the freak-offs. Why are they lying still? Freak-offs was solely for the defendant's sexual arousal and gratification. Lie. For example, Cassie testified that Puffy started filming freak-offs without asking her. Ventura emphatically did not want there to be video footage of her having sex with strangers and attempted to delete such footage because she found it humiliating, disgusting. But at the trial, we found out that all of the videos and text messages were on Cassie's phones, no? Right? And that these are all consenting adults. The defendant used freak-offs films as blackmail to make Cassie and Jane continue participating in the freak-offs. That's a lie. They were willing participants. Here's a case they referenced from 1968, a case they referenced from 1975, 1976, page 40 of 58. Page 41 of 58. There is no evidence in the record that at the time of transport, the defendant intended to film anyone at all. Instead, the record shows that at the time of transport, the defendant intended that Ventura, Cassie, and Jane and the commercial sex workers would engage in prostitution. Freak-offs were designed specifically for the defendant's sexual arousal and gratification. That's a lie, Judge Submaranian. Page 41 of 58, last paragraph. Page 42 of 58. The record is replete with evidence that the defendant orchestrated freak-offs specifically for his own sexual arousal and gratification. That's a lie. The defendant refusing to let Jane Doe use a condom because I don't like to do it with all that shit. That was this lady. Here at the bottom of page 42 of 58, Judge Submaranian, they mention USC 2422 and USC 2423. There was no force, there was no coercion, there were no minors involved. So I don't even know why they're bringing that up. Cassie and Jane testified that they had to participate in freak-offs and hotel nights, sometimes every week. Another fucking lie. Page 43 to 58. That's a lie. We heard that at the trial. The standard is clear, page 44 of 58. We're almost done, y'all. The standard is clearly met. For example, with regard to Ventura, the jury heard evidence that in late August 2009, Puffy transported Jules Theodore from Los Angeles to Manhattan to participate in a freak-off with Cassie. Cassie explained that Theodore was one of their regular escorts, and the escorts were paid to have sex with her. On this particular occasion, the defendant texted Theodore in order to coordinate his travel, including Theodore with flight details for a flight from Los Angeles to New York, and provided Theodore with the hotel number where the freak-off was going to take place. This is a grown man doing business with another grown man. These are consenting adults. The evidence related to hotel nights with Jane was equally clear. Page 45 of 58. Approximately 90% of the time that Jane saw the defendant, there was a hotel night. One of the regular escorts at these nights was Cabral Williams. Jane, page 45 of 58. This was Jane Doe's occupation. Jane Doe sells kitty cat. This is what she do. This is what she do. She was doing that on her OnlyFans page. Page 47 of 58. The defendant points to conversations he had with Kreshover, who told the defendant about the escorts rates and says after the defendant had been hiring escorts from Cowboys for Angels for years, these men were paid for their time. These men were paid for their time by Puff to legitimate businesses, not prostitutes. Page 49 of 58. And when considering Rule 29 arguments, all inferences must be drawn in favor of the government, and the conviction must be upheld if any rational trier of fact could have found the defendant guilty, regardless of whether the evidence being reviewed is direct or circumstantial. Daniel Phillip explicitly testified that he was paid to have sex. What did Cassie Ventura give you money for in around 2012? To have sex with her. So that's it. That's it. Judge Submaranian, you must acquit Puffy with Rule 29. Puffy won. He beat the RICO. He's done almost a year in prison. You've denied him bail. You got to do the right thing, Judge Submaranian. You got to do the right thing, man. My coffee cold now. I'm still gonna drink it though. See y'all tomorrow for my next video on the Rule 33. Peace.